Hello and welcome. UVA Speaks is a podcast of Lifetime Learning, a division of the Office of Engagement at the University of Virginia. Lifetime Learning brings the knowledge and expertise of UVA's faculty to the university's alumni, friends, and families. My name is Susan Lynch, and I am the Associate Director of Lifetime Learning at the University of Virginia's Office of Engagement. This podcast features Craig Konnoth, the Martha Lubin Karsh and Bruce A. Karsh Bicentennial Professor of Law at the University of Virginia School of Law. Professor Konnoth writes about health and civil rights, as well as health data regulation. He's also active in LGBTQ rights litigation and has filed briefs in the U.S. Supreme Court and 10th Circuit on LGBTQ rights issues. In this podcast, Professor Konnoth will talk with us about LGBTQ rights in the United States as it stands today. So thank you, Professor, for speaking with me today.
Thank you for having me, Susan.
Great. Thank you so much. So first, I wonder if you could provide an overview of the issues in the LGBTQ movement in the last about 10 years or so.
What's interesting, Susan, is that the issues have changed quite a bit. So 10 years ago, marriage equality was not the law of the land. What we see happening, so between 2013 and 2015, there was a mass of marriage litigation cases. And then in 2015, of course, the court came down with a decision that said that the Constitution required marriage equality across the nation. In the years after that, we see a movement seeking employment discrimination protections. And the Supreme Court in 2020 said that federal statute protected LGBT individuals from employment discrimination as well. So those issues, of course, were important issues, and there are some aspects of those that still must be addressed. But those baseline protections have been recognized by the Supreme Court at the national level. But what has happened since then is that there's been a shift in emphasis, and that shift we see in three different ways. The first bucket of cases has to do with exemption claims by those who say that recognizing equality for LGBT individuals violates their speech or religion rights. Now, those claims have existed for a long time. They go back to days where people claimed that having to give equal protection to Black people and other racial minorities violated their speech or religious rights as well. And those claims have existed with LGBT people for many, many decades. But they've really come into prominence both as baseline protections were put into place for LGBT people and as the Supreme Court has moved towards the right and has started giving special and particular protections for religion. The second bucket has had to do with transgender individuals. The fact is that in many ways, I think a strategy that has been used to attack LGBT rights in the nation has been to pick vulnerable groups. And as gay and lesbian people have received protections, transgender people have been seen as weaker and more vulnerable in many ways. And I think that as a result, we've seen a huge number of bills, 500 plus, that target transgender individuals, particularly transgender students. And I should note that these students are the weakest and most vulnerable, because if you look at, for example, poverty rates or mental health issues or suicidal ideation, the rates of all of these are just so much higher among transgender youth. And then the final issue I think the LGBT movement is reckoning with is the recognition that we can't go it alone. So until about 2015, the movement, I think, was heavily funded by those seeking marriage equality, and the money mainly came from white men, frankly, to put it to if I'm going to be honest about the demographics there. And when the movement and when marriage equality became law of the land, many organizations began to fear a loss of funding. And then, of course, with the change in administration, there was a massive attack on LGBT rights across the board. And I think what people realized was that we were not the only ones being singled out, in the sense that while LGBT rights were being attacked, so were immigration rights, so were the rights of minorities, so were the rights of women. And I think it became clear that our fate was linked to the fate of all of these groups. And so I think what the movement has been trying to figure out is how do we build relationships with other groups, trying to help them, trying to get them to help us, frankly, as well, in a way that is collaborative and productive. At the same time, you don't want to step on anyone's toes and reinvent the wheel. So I think that those are the three main areas in which the movement has pivoted in the last decade or so.
Well, thank you so much for that overview. I wonder if I could move up one of the discussions I wanted to talk about and thinking about, groups to align with the overturn of Roe and sort of what that means for women, and was a big blow for many women and for anyone who can get pregnant. What does that mean for the LGBT community? And with that, is there an opportunity to bring those communities together under what is a very difficult time?
Yeah, absolutely. So I'll start out broadly, and I'll sort of then target that particular point that you made. So when I say I want to start out broadly, I want to think a little bit about the alliances and the model that the LGBT rights movement has relied on historically. So let's consider, for example, the model of impact litigation. And what I mean by impact litigation is litigation that lawyers adopt to change the law in ways that benefit minorities across the board. So Brown versus Board of Education is an example of this. You bring a case to change the law, to strike down state laws that require segregation. Similarly, Roe versus Wade. Lawrence versus Texas is a case that struck down laws that criminalized same-sex intimate conduct across the nation. So these are all examples of impact litigation. Now, I want to emphasize that the LGBT movement owes debts to the movements that came before it, certainly the women's rights movement and the racial justice movement. So the racial justice movement began I should say the LGBT movement began with individuals, with LGBT individuals very self-consciously analogizing themselves and thinking of themselves as a group that was analogous to racial minorities that suffered injustices and so on. And this was a major shift. In the 1940s, as I've documented in previous research of mine, you see LGBT individuals thinking of themselves as sick, as psychiatrically defined. And then as the 1950s and 1960s wear on, you see the shift in consciousness where LGBT individuals specifically invoke the racial justice movement as changing their sense of consciousness. And you see the creation of legal organizations, of legal strategies that seek rights based around the racial justice movement. Now, this is something that the LGBT movement has in common with the women's rights movement, because the women's rights movement does the same thing. Ruth Bader Ginsburg is going to court very specifically and deliberately making analogies to the racial justice movement. So on one hand, you have this consciousness building and many of the strategies that come about as because of the racial justice movement. When Loving versus Virginia comes down, which was the case in 1967 that struck down laws prohibiting interracial marriage, one of the conversations that began in the LGBT movement was whether marriage equality that segregated based on sex as opposed to race, whether those laws should also be vulnerable. And the logic very much was that if you've got laws that tell you the race of the person you have to marry, then why can you have laws that tell you about the sex of the person you want to marry? So that was 1967. Then you see in 1973, Roe versus Wade comes down. And Roe versus Wade, of course, holds that there's a due process right, or held, I should say, that women have a due process right to make decisions regarding bodily autonomy, specifically around reproduction. And that case became the cornerstone, I should say, to a significant degree for the LGBT movement. At first, the LGBT movement said, look, we're going to try and make equal protection arguments. And those arguments went to the Supreme Court in the 1980s and failed. And so then they turned to due process, and they said, look, just as people have the right to reproductive autonomy, that people, among which a number of women have the right to sexual autonomy, so should LGBT people. And the court finally vindicated that claim in 2003 and said that laws that criminalize same-sex intimate conduct are unconstitutional. And the court relies on similar arguments among other arguments, I should say, in holding that individuals, that same-sex couples have the right to marry, again, recognizing this broad right to sexual autonomy. So then the question arises, if Roe versus Wade is invalid, then to what degree does the logic of these cases survive that recognize the sexual and romantic autonomy of LGBT individuals? Now, I should say that with these other cases, so I get the question, so does the striking down of Roe versus Wade mean that marriage equality is on its way out? And I actually am not quite sure how that would necessarily occur, I think both politically as well as legally. From a political point of view, I think, as of now at least, touch wood, the gay rights movement is in a stronger position. And I should note that part of the reason it's in a stronger position is because let's think about the people who do marry in this, in the same-sex couples as well as different sex couples, right? They tend to be better off, right? And people who are invested in same-sex marriage tend to be the well-heeled individuals of the movement, among which I number, though I am not married myself. But the fact is, if you look at abortion, it's mainly the people who are affected most by abortion bans are poor women of color, right? And so I think that just as a political matter, I think marriage equality is on stronger ground. I think legally, it would be harder, I think, for states to pass a law that sort of allow for incremental, incursions into marriage equality. So the way that, Dobbs, the case that overturned Roe, came about was there were numerous cases between 1973 and 2023, over those 40 years that basically, 50 years, sorry, that basically, slowly shaved off the women's rights to sexual autonomy, right? So the funding to abortion was cut off. Parental notification provisions were put in. The waiting periods were instituted. The time when over which women could have an abortion was slowly decreased, and so you could sort of shave away at that right over time until you finally get the court to Dobbs, right? And there are dozens of cases in between Roe and Dobbs. I don't see how this could clearly be done in the case of marriage equality. Sure, you could imagine situations where, protections for religion and free speech are put into place, such that those who claim religious objection are then given the right to flout marriage equality. But I see that more as a sort of all or nothing thing. I don't see that sort of happening, incrementally as we see in Roe and in Dobbs.
Well, I'm glad that there's some optimism in regard to that, because certainly we do not want to see that overturned. So thank you for that. I wonder how the Supreme Court decided a case last June called the 303 Creative case. It had to do with a website, someone being as they say, hypothetically asked to develop a website for a same-sex couple, and it was. Can you tell us about that decision, what that means, and sort of what that could mean for future?
Absolutely. So again, I want to start again a little bit. I want to rewind a little bit.
Sure, please.
Because in some ways, we could have seen a case like this coming, certainly from the 1990s, but if you want to look at the racial justice movement, from the 1930s, right? Because there were claims that having to serve individuals of a different race, or having to admit students of a different race. And I'll give you, one guess as to which race that was, right? Violated free speech rights and religious rights. So, Bob Jones University is this case where the IRS said to Bob Jones University, hey, you've got to admit black people or lose your tax exemption, right? And the Supreme Court said that the IRS could, in fact, do that without infringing on Bob Jones's constitutional rights. Jerry Falwell called that decision one of the worst decisions in the Supreme Court's history. And Jerry Falwell was also no friend to LGBT people either, right? And so you can again see these alliances forming. So the Supreme Court in 1995 held that, unanimously, I should add, that the organizers of the St. Patrick's Day Parade in Boston could exclude LGBT people from marching under their own banner, right? That they had a free speech right to do so. I should note that that ban no longer exists, and both Boston and as of I should just say 2015 began to allow LGBT people to march. The Staten Island St. Patrick's Day Parade still prohibits LGBT people, but so from marching under their own banner. But anyway, and then after that, in 2000, there was a case where the Supreme Court said, well, a Boy Scout, a gay Boy Scout can be excluded from the Boy Scouts, right? And even though the Boy Scouts get state funding, right, that the speech rights of the Boy Scouts win the day. So you see these cases. Now, I think that there were three things that were particularly concerning about the 303 Creative case. Full disclosure, I should add that I was involved with the 303 Creative case, as well as with its predecessor, the Masterpiece Cake Shop case, which involved a baker who refused to serve same-sex couples. So I just want to put that out there. But I did not have any official involvement in 303 Creative at the Supreme Court. So I think there were three issues that made the case particularly concerning. The first, and the reason I actually didn't file a brief in the Supreme Court in 303 Creative, was because that really shouldn't have been standing. There was no same-sex couple that ever asked Laurie Smith to build them a website. She claimed that there was one same-sex couple, and gave a particular name. Upon further investigation, that name turned out to belong to a gentleman, and the person turned out to be a gentleman who was happily married to someone of the opposite sex with children of his own, and was quite surprised that he was said to have asked for a wedding cake for a same-sex wedding. And without making any claims as to whether the claim was manufactured to create a sympathetic speech claim as opposed to website claim as opposed to a cake making claim. It's easier to make a free speech claim based on a website, right? So without making any claim as to whether this case was manufactured, I do think it's quite troubling. Now, I said, well, the fact is that Colorado has never once instituted a prosecution against Laurie Smith, right? The best case that the other side had was a case where there was some investigation, at least, as to whether a law had been violated. Here, there was no violation of the law. No service had been provided in the first place. There simply was not a case here. And the Supreme Court has said time and time again, we don't sit around waiting for hypothetical disputes. You need some kind of state action proceeding against an individual for a court to get involved. Otherwise, anyone can come to us with any problem at any time and say, oh my gosh, we're worried that the state might do something, and the courts would be overflowing. So here I think the court quite lawlessly, frankly, sort of reached out, and it wanted to reach out to my mind because, again, it is hard to get a case. You get a baker. Well, is baking speech? Is baking not speech? Right? You get a florist, which was another case. Is a floral arrangement speech? Is it not speech? But this was the perfect case for the court because it involved a website. And even though there wasn't any standing, the court wanted to reach out and make law in this case, which I think it did quite lawlessly. So that was my first big concern. The second concern, I think, had to do, and I've written about this in a piece that's forthcoming in the Columbia Law Review, had to do with the fact that the court claims that by refusing to provide services for same-sex weddings, the baker isn't actually engaging in anti-gay discrimination. And I think that is really problematic, right? I mean, what the court says is, they're happy to serve, to give a same-sex couple or give a gay person a wedding cake for a straight wedding. Let's say someone's coming in to buy a cake for their friend's straight wedding, or maybe they happen to be, I don't know for what reason, marrying someone of the opposite sex. Make a cake. Similarly, the baker will refuse, or I should say, the website designer will refuse a straight person's request to make a wedding website for a gay wedding, right? So we aren't discriminating against the people based on their sexual orientation. We're simply refusing to provide certain products. And I think that this is somewhat problematic. And Justice Sotomayor, in her dissent, says, "Oh yeah, right. So we've got all of these situations where people are going to come in to asking for wedding cakes for their straight friends' weddings, right?" And I should add, it led to these bizarre hypotheticals in the court. Justice Alito at one point starts talking about whether a Black Santa Claus can refuse to help a child or to have a child who is wearing a Ku Klux Klan outfit. Right. And I think everyone in the courtroom, I wasn't in the courtroom, but I think everyone in the courtroom, from what I hear, was completely flummoxed. And then at some point, he makes a joke about whether Black children will wear a Ku Klux Klan outfit and go with a Black Santa Claus. Right. And I think it just sort of went downhill from there. And so these hypotheticals, I think, don't really make sense. And then I think the third thing that really troubled me was, so the other side, or I should say the side on behalf of the state, brought up a case that the Supreme Court said that the government could refuse to provide funding to law schools that said that discriminatory policies by the military would result in the military not being allowed to recruit on campus. Law school said, look, and this was when the military had discriminated against gay people, and law school said, look, because of that discriminatory policy, that violates our speech rights to have the law school on campus recruiting. We've got to send out emails, telling students where they could go meet law school recruiters. We've got to send emails on behalf of the recruiters. That violates our speech rights. These are emails that we've got to send as law schools that believe very strongly in the equality of gay, lesbian, and trans people. And the Supreme Court said, no, that's fine. You can send these emails. That doesn't violate your free speech rights. And the Supreme Court really sort of brushes aside the speech right claims of the law schools in those cases. And I think we're left with this very troubling world in which suddenly the speech claims and the religious claims of those who are anti-gay and anti-trans get precedence over the free speech and belief claims of those who are pro-gay and pro-trans, and I think that left me with a huge set of concerns.
Absolutely. Thank you so much for all of that background. That's really very helpful. I wonder if we could switch to transgendered rights right now. I recall there being many cases in states around which bathroom one could use. Now seems to be cases coming up in states around restrictions for gender affirming care. Again, for youth, as you're saying, for those that are the most vulnerable. I wonder if you could just give us some overview of where we are sort of nationally and within states around transgendered rights.
Yeah, so it's hard to know where to start, frankly,
right?
Because there are just so many. There's just so much out there. There are there are so many bills that I actually look it up day by day. I just looked it up. There are 550 bills that seek to target trans individuals across the country. And 331 of them are currently active, I should say, right? So I would say that they fall into, I'm going to say bravely, three categories, but there are going to be more. So for those of you who are experts, I apologize for glossing over this. I think the biggest is on the issue of trans healthcare, where jurisdictions say that providing care for trans kids violates a whole slew of laws in the jurisdiction, from medical malpractice to child abuse and so on and so forth. And the second category has to do with various other school limitations, from the names that trans people can use to parental notifications to the locker rooms and the bathrooms that trans people can that trans kids can go into. And then in the third category, I'm just going to say miscellaneous, from name change laws to, religious protections to sports, I should say. I think sports maybe should be in a category by itself, and so on and so forth. I'll talk about healthcare first, and then I'm happy to talk about the others if that would be helpful. With healthcare, one of the issues is that there is limited evidence out there, right? It's very hard to carry out a randomized controlled trial that involves medicating children, right? And when I say hard, I mean unethical. We shouldn't do it, right? But what we do know is that rates of suicidal ideation among trans kids is very high. And what we do know, the best evidence out there suggests that when trans kids are provided care, that things get better, right? That is what the best evidence suggests. Now, a recent report has made the news. It's come out of the National Health Service in the UK. And I should say that, in the UK, since with the Tory government, so, the equivalent of a right-wing Republican government there, the politics of trans rights in the UK have also become very toxic. And the policies in government have also become quite toxic. So a report recently came out that claimed that that because of the lack of evidence, that various kinds of care for trans kids should not be provided, and in a country with a national health service, that effectively constitutes a ban on providing the care. And many commentators in the U.S., including, for example, David Brooks, have pointed to it and said, "Oh well, that means we shouldn't do it." Now, I'll say a couple of things about that. The first is that when it comes to medical care, and I say this as a health law professor, evidence can sometimes be limited, right? You can't have a randomized control trial and everything, especially when it comes to pediatric care. And the standard of evidence being demanded when it comes to trans kids' care is just so much higher than the standard of evidence being demanded for anything else, right? And so I think that by itself is problematic. Why, when it comes to trans care, are we asking for more, right? That's classic bigotry. Right? When it comes to the specific group in question, we're asking for more. Now, I'm not saying we shouldn't have more evidence. I welcome more evidence. I'm on record in an article in the journal in the pediatrics, which is a major medical journal, saying we want more evidence. Right? But this is not the way to do it. The second is we've got to look at the best evidence available. Right? The choice is it's not like if we do not carry out procedures or do not provide the care that trans kids or kids who believe they are trans, if you want me to adopt the claims on the other side, it's not like they're just going to go off skipping happily into the sunset, right? Many of them kill themselves, right? That's the fact. And so you've got to think about what happens if you do not provide the care. And that is really not being taken into consideration. And then third, I think there's this massive procedural issue, right? So as lawyers, but I think as people who live in a democracy, we should care about who gets to participate in decision making. And if you look at those who participated in the decision-making of the report, you don't have experts who provide trans care who participated in the decision-making of the report. Now, I should say that we actually aren't quite clear on who wrote this report. And the reason I'm emphasizing this report so much is because it's all over the American news and it's being cited in all of these laws, right? And we should know who worked on the report, but we do know that in terms of the people who were released, the names who were released, there are many people who are anti-trans and are really no expert, no one who's really historically provided care. And what's problematic is, I know for a fact that that many of these commentators, like David Brooks, have consulted with people who are experts on the issue, but have sort of ignored the information and evidence provided and have just sort of turned to the report, right? And I think that is deeply problematic. And so I think we need to have a sort of open dialogue about this, but we do need to look at the evidence out there. And I think the evidence quite clearly suggests that, proceeding as if nothing is happening, or limiting trans care in the way that the report is suggesting is more harmful, according to the existing evidence, than providing the care.
Thank you so much for all of that background. That's really very helpful. And finally, as we wrap up, I wonder if you could, we were looking sort of backward, and I wonder if you could look forward and sort of what are the issues? We've talked about some, but we're heading into we're in an election year, uncertain times. So where is the community and what are the big pieces? I mean, I'm sure we've talked about them, but what is it that is being worked on now and sort of looking forward into the next few years?
Yeah, absolutely. I think the community is in a very interesting place because I think that in a way we're back to, I'm going to say, the 1980s and 1990s when we had a hostile Supreme Court. And we realized that sort of, we're playing defense when it comes to litigation. We aren't going to get a court that's particularly friendly to LGBT people at all, right? And so how do we advance claims at the state level? How do we change hearts and minds? And how do we build alliances while at the same time trying to limit the damage that a very activist Supreme Court will try and inflict on any gains that are achieved, right? Because the fact is that even if you get wins in states, right? So, for example, in Colorado for a long time, I should say, but in other states as well, we're seeing these wins prohibits discrimination based on sexual orientation and gender identity. But then the Supreme Court says, well, anyone who claims a speech exemption in when there's a colorable, expressive claim, and who knows how broadly that's going to sweep, can violate and flout those laws whenever they want, right? How do we limit the court from doing things like that, right? So I think that is that's the challenge moving forward. Now I should say that of all the movements, right? So I am an immigrant, gay person of color, right? And so I'm a member of multiple communities at the same time. And I should say that I think the gay rights movement has done an amazing job of sort of changing hearts and minds. Right. And I think that, as it moves forward, thinking about how it can do that and how it can maintain the narrative, at the political and social level will be important as it sort of forges ahead to try and keep the gains it has made in the last decade.
Thank you. Thank you so much, Professor Konnoth, for sharing all of this information about where we stand today, where we are looking into the future for LGBTQ rights. It's concerning time for advocates and allies, so I appreciate you sharing your knowledge and expertise with UVA's alumni, friends, and families.
Yeah, thank you very much, Susan.
And thank you to everyone for listening. For upcoming podcasts and other Lifetime Learning programming recordings and blogs, please visit our website at engagement.virginia.edu/learn. You can also find our podcasts on the Virginia Audio Collective, which is a network of UVA podcasts hosted by WTJU Radio and can be found at virginiaaudio.org. So thanks again, and we look forward to you taking part in future Lifetime Learning programs.